Good morning, everyone. I would like to thank you again for joining us. We'll go ahead and get started. We've got a lot to get covered today. We're going to discuss what is considered time worked under Fair Labor Standards Act and what you need to know. We obviously won't be able to get to every circumstance today, but we're going to try to touch on many of those. If you have a question during the presentation, please feel free to type that in the question box and send it over. I will attempt to answer those at the end of the presentation if we have time. So again, let me welcome everybody, and let's go ahead and get started. So what are hours worked under the Fair Labor Standards Act, and why does it matter to us? Obviously, all covered employees, those who are non-exempt, must be paid for all hours worked in a work week. So in order to ensure we pay them properly and that we track those hours, we need to know what hours are that are considered work. In general, hours worked include all time that an employee must be on duty or on the employer's premise or at any other prescribed place of work from the beginning of their first principal activity of the workday to the end of the last principal activity of that workday. This also includes any additional time the employee is allowed to or suffered or permitted to work. So when we talk about suffered or permitted to work, so when we take even stuff, work that is not requested, but suffered or permitted work, for example, would be an employee who may voluntarily come into work early and they start their shift, or one that stays late. They have a desire to finish an assignment, a task, or wish to correct an error they might have caused earlier in the day and they want to remedy that error. It could be preparation time, reports, coding of hours worked for the day. The reason really is immaterial. If the employer knows or has reason to believe that the employee is continuing to work, the time is considered work. It's considered suffered or permitted. So when we talk with regards to rework, occasionally you hear about an employer who might say, well, my employees are required to fix any mistake they have made. And I have heard of a few that actually have had it done on the employee's own time because they've already paid them to make the work, to do the work, and they don't want to pay them to remedy the mistake they've made. Under the Fair Labor Standards Act, any correction of work, or rework as the term is used, is considered work time, even if it's done voluntarily by the employer or required by the employer. So just know that having to work or do rework is actually considered worked time under the Fair Labor Standards Act. This rule would also be applicable for work that is performed away from the premises or on job sites or even at home. So if the employer knows or has reason to believe that work is being performed, it must count as time worked during the day. In all such cases, it is the duty of management to exercise its control to see that the work isn't performed outside of the work hours they've prescribed. So the management or the company can't sit back and just accept the benefit without compensating the employee for that work. And having a rule simply stating that there can be no work performed outside of these hours isn't enough. Again, it goes back to management has the power to enforce the rule and thus must therefore do everything they can to prevent it from working, which of course would be like disciplinary actions. So what is work time? Well, it's all the time spent by an employee performing activities which are job related. This could include time spent during regular hours on the clock, plus off the clock time. Time spent doing job related activities which benefit the employer. So an employer suffers or permits an employee to work if it allows the employee to do any work outside of those hours, if they know it or should have known or reasonably could have known that the employee was doing the work, or they could have found it out by just looking a little deeper. So keep in mind as employers, we can't pretend that we aren't seeing the work is done or knowing that this work is being done outside of normal working hours. Off-the-clock work may include, as I indicated earlier, coming in early, starting your work shift before your official start time. It could be staying late to remedy errors. Those things, if the employee does work, they are considered actual work tasks. Obviously, it wants to be actual work tasks, is considered time worked. time setting up equipment before an official shift starts, closing down things after a shift ends, doing work-related tasks on the way home, dropping off mail for an employer, dropping paperwork by to a client's house. This is all considered time worked, even though it's after the employee's shift has ended. So we've allowed it to happen. It is considered time worked. Then we move on to wait time and on-call time. So some individuals have employees who are considered a wait status. We sort of intermingle these two categories quite a bit. Or they have employees that are considered on-call employees. Wait time, of course, is paid if the employee is engaged to wait, and we'll discuss what we mean by engaged to wait. If they are unable to use the time effectively for his or her own purposes, it is typically engaged to wait time. Wait time is usually short in duration, and waiting is an integral part of the job. So, for example, if we were to take a receptionist who is reading a book while waiting for a customer to come through the door or to answer a telephone call, a fireman who plays checkers while waiting for an alarm to go off, a waitress or waiter in a restaurant waiting to serve a customer upon their arrival. This is all they're engaged to wait, so this is considered time worked. The rule is the same for employees who work away from the plant or the office. For example, it might be a repair person who has arrived at a residence, a customer's place, to do a work order, or time spent by a truck driver who has to wait at or near a job site for goods to be loaded or unloaded. Or it could be time spent by a bus driver who reaches his destination, drops off his passengers, and has to wait with the bus and guard the content of the bus for the end of that trip and the return trip home. These are all cases where the time truly could be considered work time. They've been engaged to wait, so this is kind of an integral or essential part of the job. Time may be hours worked even though your employee is allowed to leave the premise or the job site during such periods of inactivity. Periods during which the inactivity occurs is unpredictable, and they're usually short in duration. In either event, your employee is unable to use the time effectively for his or her own purposes, and thus the employee's time belongs to the employer, and then again becomes time engaged to wait. On the other hand, if you have a truck driver who is sent to from Washington, D.C. to New York City, they leave at 6 a.m. in the morning and they arrive at 12 noon, and then they're completely and specifically, when we use the word specifically, we'll talk about that, relieved from all duty until 6 p.m. that night, when they're then re-engaged to do a return trip home. This time is really not engaged to wait. The individual actually is off duty and is able to use the time for their own purposes. We usually have to give very specific and careful analysis to determine whether or not somebody's time away, where they're not engaged, is actually reasonable enough for them to engage in their own personal activities. So off-duty wait time or layover time is a period during which the employee is waiting to be engaged and is not hours worked if your employee is completely relieved from duty. The periods are long enough to enable the employee uses the time effectively for his or her own purposes. The employee is definitely told in advance that he or she may leave the job, and your employee is advised of the time that he or she must return to perform the following or follow-up tasks. All of those above requirements must be met for the employee's time to be considered their own time, time that they can use to engage in their own pursuits, and thus wouldn't be work time. When we talk about on-call time, an employee who's required to remain on call on the employer's premise or so close that they cannot use the time effectively for their own purposes, this is truly on-call time and the employee is engaged to work. So this would be considered time to work. If the employee is just engaged and has to tell the employer where they're going to be or how they can be reached to be returned or called upon to return to work for a work activity, that time truly may not be time worked. We have to look a little deeper to determine whether or not the time that they are on call but not actively being used in pursuits of work activities is actually long enough in duration that the employee can actively engage in personal pursuits. And how we determine that is we consider whether or not the employee's use of the on-call time is impacted by the frequency of the on-calls they receive. For instance, you may have an individual who is on call for technical questions, and during an hour period where they are trying to eat their dinner or read a story to their child, they receive 2 or 3 phone calls. That really isn't an effective use of their own personal time. They're not able to use that for their own personal time. Their interruptions are enough that it would constitute that the employee truly is under work hours for that duration of time frame. But if you have somebody who is out of work for 12 hours, they get off work, they go on call for the evening, and during that entire 12, 14, 16-hour period, they receive 1 call, a couple of minutes long, they're able to use their time effectively. Another scenario might be individuals who are on call for snow removal. They can pretty much use their own time effectively, do whatever they need to do, take care of their own personal issues, needs, cleaning house, etc., reading to their children, because chances are they're going to be called back at a given time, not many times throughout the night. And then, of course, as soon as they are called into work, that time becomes work. So your on-call time and your wait time all goes back to circumstances. We have to look at the circumstances involved, the frequency, and the duration. Rest and meal periods. The Fair Labor Standards Act doesn't require meal and or break periods or rest periods, except in cases of course child labor. So you start getting into individuals who are under 16 years of age, it may even be 15. There are certain break and lunch hour requirements. But from a general perspective or rule, the Fair Labor Standards Act doesn't require that employers provide meal or break time periods. However, if they do provide a rest period, a break, of 15 minutes to 20 minutes in duration, they actually have to count that as time worked. They can't offset it for other work times, such as compensable wait or on-call time. If the employer has a policy where they offer the employee or give the employee 1, 2, 3, whatever case may be, based on their shift, rest periods of up to 10, 15, 20 minutes, that time is considered work and would not be deducted from the individual's pay. However, a bona fide meal period, if the employer elects to offer a bona fide meal period, the time is not compensable. In general, to be bona fide, it must be 30 minutes or more in length, and the employee has to be relieved of all duties during that meal period. So if we have them sitting at their desk trying to work, taking calls, viewing emails, they are working. That becomes work time. You don't have to let the employee leave your premises for the lunch or meal period. You can actually require them to remain on the premise as long as they are free of all duties during that meal period. That time is non-compensable, so we can deduct that from the individual's pay. Telecommuting. I'll discuss this briefly, but the biggest caution around telecommuting comes in the employer's ability to define what those telecommuting guidelines are and making sure that they establish a very good, a very effective way to track and pay all hours worked by telecommuting employees. So again, it goes back to if you have reason to believe that work is being performed, you're not visually seeing it, they're not there for you to see it, you have to make sure that you have a clear, defined, and communicated telecommuting policy or guidelines for tracking and reporting of hours and days of work by these individuals, including deviation reporting requirements. So if you've set up a guideline that your telecommuting employees are going to work from 8 a.m. to 5 p.m. Monday through Friday, you want to make sure that in that telecommuting policy that it defines any deviation from those hours, times, or days are brought to the supervisor's attention so that we know that work is taking place. Otherwise, we have no way of knowing. You want to consider requiring your telecommuting employees to sign a telecommuting agreement that clearly outlines those requirements so that both parties are very clear on that expectation. One of the biggest areas of caution is requiring the telecommuting employee to attend in-person meetings or training that's otherwise performed at the employer's place of work. In some recent telecommuting litigation, employees have been claiming that their time traveling to and from those meetings is considered work time. And in some cases, it has actually been ruled that it is considered work time. A lot of what comes into play in making that determination is if that travel to and from those meetings or training take place across or during the employee's regularly established working hours, and also the duration or the distance they have to travel to get to the employer's work site for that meeting. So just be cautious if you're going to allow telecommuting, and make sure you have very clear, defined telecommuting guidelines and expectations. Lectures, meetings, and trainings. Your lectures, meetings, and trainings need not be paid if they meet the following criteria. And again, we always have to warrant caution because we put these guidelines in place and we try to make them black and white, and typically they're not all black and white. The training takes place outside of normal working hours. It is voluntary, not job-related, and no other work is concurrently performed during the training. In order for training to be voluntary, we have to make sure that the employee in no way feels like their position, opportunity, or status with the company is in any way impacted by virtue of them not attending it. So to be truly voluntarily, it has to be truly voluntary. There cannot be an underlying feeling or indication given or felt by the employee that says, if I don't attend this, it could impact my future with the company. So make sure that if it's truly voluntary, it's truly voluntarily. So attendance for independent training taking place on the employee's own initiative after hours is not hours worked for the employer, even if the course is business related. For instance, an individual who is performing statistical analysis for the company may choose to take some statistic classes at a college outside of working hours, after hours, just so that they can improve their effectiveness. Those courses are truly at the employee's discretion and not considered work time, even though they may be job related. There are special requirements that must be met for an apprenticeship training program not to be considered work time. So if you've got apprenticeship programs that you're dealing with within your working environment, you want to make sure that you are aware of the fact that there are special guidelines in order for that apprenticeship training program not to be considered work. Some of that criteria includes the apprentice is employed under a written apprenticeship agreement or program which substantially meets the fundamental standards of the Bureau of Apprenticeship and Training of the U.S. Department of Labor, and such time does not involve productive work performed by the apprentice of regular duties. So if you've got an apprentice plumber and you're having them actually perform plumbing tasks through that apprenticeship program, that's going to be time worked. So make sure that if you're doing an apprentice program and trying to consider it not time worked, that you're very careful that you've met all of the requirements to make that program not be considered time worked. I wanted to go back and make one note. As an enforcement policy, time spent on in an organized program of related or supplemental instruction by an employer. So maybe you as an employer have opted to offer English as a second language to your employees. These types of programs offered to your employees under these programs may be excluded from work time. And that goes back to similar to the apprentice program. So you can offer a program. It can be considered work-related, but it is, again, voluntary, done at the employee's discretion. They've chosen to do it. So from an enforcement policy, the Fair Labor Standards Act is not going to tell you that has to be time worked. They're just saying that you need to make sure and meet the criteria for those types of programs to ensure that they are not considered time worked. Work off-premise, off-clock, and after hours. This is a bit of a repeat, and I repeat it because it is incredibly important, especially in the day and age that we work in and live in now with our iPhones, our iPads, the accessibility of our employees. Again, hours worked include all of the time that takes place for the employer's benefit, whether it's on or off premise, and whether it's inside or outside of standard hours. For example, checking of and responding to emails. If you have an employee who is checking and responding to emails, that's a record. It's a track, basically a hard record that they could use if they came in and audited and said the employee's been working after hours, and you've got record. I mean, you've got emails that are being responded to after hours from this employee. So there's a lot of danger involved in not making sure that we set clear expectations and control those expectations within our work environment. So again, I'm just cautioning everyone to make sure that you are tracking, looking for, and being aware of work that takes place off-premise, off the clock, and after hours or before hours to ensure that employees are paid correctly and that we manage that expectation so that we as employers don't incur expenses or penalties that we don't want to suffer. We appreciate our employees wanting to do that, but we can't, of course, accept that without compensating them. So we get into sleep time and other activities. In order for sleep time to be considered not work time, if you have an individual who is required to be on duty for less than 24 hours, all hours are considered work, even though the employee is permitted to sleep or enjoy other personal activities when not performing work-related tasks. So you may have somebody who has to monitor machinery or be available. I'm trying to think of a good example. Your oil rigging individuals typically have to be aware and available and checking those machines on a regular basis, and they may be required to remain on site for long periods of time. They are typically performing work tasks or considered working, whether they're performing a work task or not. If they're required to be on duty for 24 or more hours, an employee required to be on duty for that period may actually agree with the employer to exclude certain time frames from their work. That would include like bona fide sleeping periods of not more than 8 hours per day, provided that the employer has provided an adequate sleeping facility and that the employee can usually enjoy an uninterrupted night's sleep. There can be no reduction in work hours permitted unless they are allowed at least 5 hours of sleep. And then we can also deduct for a bona fide meal period. So again, if we've established a policy of a 30 or 60-minute meal period, and the employee can have that without interruption, that could be time deducted from the pay. Again, you'd want to make sure that it's actually being given and taken by the employee before you deduct it, so they're not actually being interrupted. They are actually getting that time, that meal period or that sleep period away before we make any kind of deduction. In cases of no expressed or implied agreement, the 8 hours of sleep time and meal periods will be considered time worked. So if you've got a scenario where you have individuals who are going to be on site for 24 or more hours, you want to make sure that you've established a mutual agreement, that you've discussed what those sleep hours and breaks or meal periods might be before you make any type of deduction from that pay. special care and consideration mutual agreement should be given in cases where the employee resides on the employer's premise on a permanent basis or for extended periods of time. One of these scenarios I go back to there is you may have a maintenance individual who actually lives in a facility that you are maintaining, apartment complexes, housing facilities. That individual's time, your employee's time spent, would not all be hours worked as long as we set guidelines around what is considered work time and that the employee is actually freed up and allowed to use some of that time in their own personal pursuits. Employees who reside on the employee's premise on a permanent basis ordinarily would be able to engage in normal private pursuits and thus have enough time to eat, sleep, entertain, and other periods of complete freedom from all duties and the ability to leave premises on their own. It is, of course, difficult to determine the exact hours of work under these circumstances. So any reasonable agreement that you and that party make in consideration for all hours worked. So you want to take into consideration pertinent facts, discuss it with the employee, set up rules, and then make sure that you both agree with and understand those rules. Those will typically be accepted as a valid agreement of hours worked in this type of a situation. You've got your pre- and post-preliminary activities. These are going to be preparatory and concluding activities. This is time spent before an employee begins or after they end their principal work activities. We touched on this briefly before. This time may or may not be hours worked based on the activity, the relationship of the activity to the employee's principal work activities. So when we talk about principal work activities, those are activities that the employee was hired to perform, and they're closely related activities that are necessary for the performance of the principal activity, such as reporting time, prep and or cleanup time, donning and doffing of protective wear or gear. Now, the courts are actually still struggling with what the clothing aspect of that is. So as employers, we want to be careful. Some of the things we might consider, like showering at the beginning or end of an employee's work day for the employee's own benefit and the convenience. It's not directly related to the employee's principal activity, wouldn't be considered work time under those hours. Another example would be if your employee travels to a parking area and completes his or her trip to the work site in a company bus. The time spent traveling in the bus from the parking area to the actual place of work or the job site is not hours worked. Again, walking, riding, traveling to and from the actual place of work to where the employee performs the principal activity would also not be considered time worked. The only exception to this would be is if you have a contract or it's been custom or practice of the company to actually pay in those scenarios. So if you've had a practice of doing it and you're going to stop it, make sure that you've clearly defined that and that it's applied to everybody across the board evenly. And if you're not going to, then make sure that you continue the practice and again apply it fairly and consistently across all of the employees. There are, of course, two exceptions, which I touched on just briefly, to when an employer is considered time as hours worked. And that's if the time is considered hours worked according to an expressed provision of a written or unwritten contract between the employer and employee, which I said could be a contract or a practice, and then, of course, in accordance with customs and practices. So again, let me emphasize that. If you have a contract or a practice that leads someone to believe that the time walking to and from a particular area to the workstation or riding in a bus from a parking lot to the workstation, if you have a practice or an express contract or implied contract that says this is time worked, then it would truly be considered time worked. On a follow-up note, though, only the amount allowed by the contract or practice would be considered time work. For instance, if you have a practice of allowing 15 minutes of commute time from the parking lot on a bus to the workstation, and for some reason an individual takes 25 minutes, or it takes 25 minutes. The practice or the agreement is for the 15 minutes, so that is what would be considered compensable time. When we talk about principal activity, these are activities which your employee is employed to perform. It's what they were hired to do. Activities include any work or consequence performed for your business, no matter where the work takes place. So whether it's on your premise or at another premise. The employee's principal activities also include all activities which are an integral part or essential part of his or her principal activity. So in operating a lathe, the employee may frequently, at the beginning of his or her workday, have to oil the machines, check everything, make sure it's all worked, and that everything is functioning properly, or install new cutting tools. All of these activities are considered integral parts of a principal activity, and thus time would be considered work time or essential to that work time. Another example might be an employee in a chemical plant. They cannot perform their principal activity without putting on certain clothing to protect themselves from those chemicals. Putting on this special protective gear or wear would typically be considered time worked. And again, like I say, the courts are struggling with what is considered protective clothing or gear under the donning and doffing laws. So we should all be watching for things to come out as we move forward around that specific issue. But as an employer, sit back and look at the function. And if having to put on that protective gear is an integral part of that job, it's likely going to be considered time worked. Okay, now we're going to get into types of travel. This tends to come up quite a bit. There are several different types of travel time. So you've got your home to work travel, home to work on an emergency situation, home to work on a special one-day trip or assignment to another city, travel that all takes place in one day, travel away from your home community, and then traveling in the employer's vehicle. We're going to walk through each one of these a little bit, some in more detail than others. Home to work travel, an employee who travels from home to work before their regular day and returns home at the end of the day. In most cases, this is just ordinary home to work travel, and it's not considered time worked. This is true whether you work at a fixed location or a different job site each day. In emergency situations, for example, if you have gone to home after completing your day's work and are subsequently called back to travel to a substantial distance to perform an emergency job at one or more of your employer's customers' work sites, all time spent in such travel is time worked. Travel that's all in a day's work. Time spent traveling as part of your principal activity and between job sites during working days and hours is time worked. For instance, construction workers, they're often required to report to a designated meeting place where they're all given instructions. They pick up tools or supplies or perform other work prior to traveling to the work site. The travel from the designated meeting place to the work site is part of the day's work and is counted as hours worked. However, you could have a scenario where employees may all elect to meet at the work site or at the employer's place of business, get into a company vehicle, and all drive together to a work location. The only individual that is considered truly doing work time is the individual driving that vehicle, if, of course, it is not required. So you've offered a form of transportation to this group of individuals to the first job site of the day. They can choose to come to your place of work and take that ride to that first location, or they can drive there themselves. In either case, those that are passengers in the vehicle or that are driving themselves to that first job site, that's not time worked. However, the person driving that vehicle to get everybody to that job site, if it's a company vehicle, that is time worked for that individual. Travel away from your home community. So travel that keeps you away from home overnight is travel away from your home community. Travel that takes place during regularly scheduled working hours is time worked. So if you're traveling and it cuts across your normal working hours, this is considered time worked. And we'll discuss a little bit further what happens if you get outside of those working hours. Travel that takes place outside of regularly scheduled hours may or may not be hours worked depending on the circumstance. So what we come into here is that travel that keeps you away from home overnight, as I indicated, is travel away from your home community. So that travel time is clearly work time. It takes place during your regular working hours, your scheduled working hours. You're simply substituting the travel for other duties. So if you're traveling, the hours you're in travel for that day, say for instance you are scheduled normally from 8 to 5 p.m., Monday through Friday. Travel time on a train, bus, airplane, or in an automobile during those hours is hours worked. That would be true as well for Saturdays and Sundays. Even though your normal working days are Monday through Friday, your normal working hours are what drive that. So if you're traveling on Saturday or Sunday for business purposes between 8 a.m. and 5 p.m., those are actually considered hours of work. Travel outside of regular hours, the part of the travel that occurs during your regular hours is most likely hours worked, depending again on the situation. If you're a passenger and some part of your travel occurs outside of the regular working hours, the travel outside of those normal working hours could potentially not be work time. It would depend on what's taking place during that. If you are driving while traveling, as opposed to being a passenger, then of course that travel time outside your normal working hours could be considered hours worked. If you're the one that is dependent upon getting to that destination for the employer's benefit and you're driving a vehicle to get there, those are probably going to be hours worked. As an enforcement policy, the Wage and Hour Division will not consider as hours worked the time spent traveling away from home outside of the employee's regularly scheduled hours of work as a passenger on an airplane, train, boat, bus, or automobile, unless, of course, you're performing work during that time frame. So if you've got files with you, you're on a laptop working as a passenger doing actual company work, then it would be considered hours work. But if you're just a passenger in that car outside of your normal hours as an enforcement policy, which means it's not law, it just means the Fair Labor Standards Act, as an enforcement policy, would generally consider those not hours worked. That doesn't mean that the employee couldn't file a claim saying that they are hours worked. So special one-day assignments. Different rules apply when the employee regularly works out of a fixed location. So I'm employed, I work at the Salt Lake office Monday through Friday. I typically report there, that's what I do. But I've been asked to take a one-day trip, a special one-day trip, and go down to Washington, D.C. That special assignment, I'm instructed to leave in the morning at 8 a.m. and arrive by noon, ready to work. Special assignment is complete by 3 p.m., and then I travel back home, and I get home at 7 p.m. The travel that I've just made cannot be considered ordinary work-to-home travel. It was performed at my employer's benefit, at their special request, and to meet special needs of the company and or assignment. So this type of travel would qualify as a necessary part of a principal activity for which I was hired. So every job has those special things that come into play. That's why we always put in our job descriptions other assignments as needed or other tasks as needed. So in this type of a case where the employer has explicitly requested this special one-day assignment, those hours are going to be considered hours of work, even though they go outside of my normal hours of work. So work performed while traveling. I mean, this one actually is pretty clear. I mean, we've talked about this a lot throughout all of the different presentations, but any work which you're required to perform while traveling must be counted as hours worked. This would include activities such as driving, so if you are the driver, mandatory readings, any kind of clerical work, acting as a tour guide. If you drive a truck, bus, or automobile, boat or airplane, or you are required to ride within as an assistant or helper, and you are working while riding. except during meal periods and, of course, sleep periods. Those, again, are hours worked. If you are offered public transportation but request permission to drive your automobile instead, the employer may count as hours worked, either the time spent driving the automobile or the time he or she would have spent as hours worked had you used the public transportation that was provided. So what you look at there is if an individual, you've offered them a train ticket to get to a designation, and rather than get on a train, they want to drive. You have those two different scenarios. So you can either consider the time that would have spent driving the automobile or the time that they would have actually spent had they taken the train trip. So you have actually a little bit of latitude there. Now at this point, I'm going to go ahead and I think we've got some time here. It looks like we've got a few minutes. And I'm going to see if we've had any questions that have been presented by anyone. I don't see anything right now. If you have questions, I would encourage you to go ahead and send those over. We have a few minutes. It would be nice if we could address your issues. And I'm going to see if I can take phones off of mute here. I may not be able to. Okay, it looks like I'm not able right now to take this off of mute, so I apologize. If you have any questions, please feel free to type those. If you don't have any questions, the event has been recorded. If we can help you in any way, please feel free to let us know. And again, we appreciate you taking time to attend the presentation. I hope it was helpful, and I look forward to assisting you in the future. Okay, it looks like I've got a question coming in from someone here. Let's take a look at it. Okay, it looks like I actually do have some questions here, so bear with me while I bring those up. Okay. All right, we did have a question regarding paid and unpaid meal periods. Hopefully that question was answered. You don't have to offer a meal period. If you do offer it, it needs to be at least 30 minutes in duration. The employee has to be relieved of all activities. If the employee does perform work-related activities, that meal period would become paid. If the meal period is not 30 minutes or more in duration, it is not considered a meal period. It basically goes back to a rest or break period and becomes hours worked. Let's see. Looks like we've got a couple of others here. Okay, I've got someone here saying, I assume this does not apply to salaried employees. Well, that's correct if they are truly a exempt salaried employee. So we use the term salaried and hourly sometimes incorrectly. It goes back to whether or not the employee is exempt versus non-exempt. So we tend to tie those together. We call a salaried person an exempt person and a non-salaried person, or an hourly person a non-exempt person. If they are correctly defined under the Fair Labor Standards Act as a salaried individual and they are paid a salary, correct, this would not come into play. So the key is making sure they are truly a salaried exempt employee under the Fair Labor Standards Act. Okay, let's see here. We've got another question. Okay, we've got someone asking about individuals who work for a business that is approximately 50 minutes away, commute to and from the business, and whether or not that is considered work time, and then, of course, travel between jobs, whether they're driving or as a passenger. Getting to and from the place of work is typically not going to be considered time worked. So that's your normal commute to and from the beginning of the day, the end of your day. However, travel time between job sites throughout the day, whether you're a driver or a passenger, is considered time worked. So once you have a principal activity and it starts your clock, then typically all of the work time, all of the hours between that to the end of your shift is going to be considered work time, unless, of course, it's time that has been expressly excluded, like meal periods where you're relieved of all duties, or you have made a request from an employer to take some personal time. Those things are not hours worked, but typically if you are just going in, reporting to your first job, time traveled between that job to the next job throughout the day, throughout your normal working day, those are going to be considered hours worked by both you and the passengers in that vehicle. Let's see, we've also got I think there's another one here. Let's see what else we've got. Okay, someone's asking if we have a PowerPoint of this presentation. Yes, we will send out a PDF of this at the end of the presentation to those who have attended. Let's see, another one. I have a part-time employee. She has worked over her normal schedule, but she wants to take the extra time she worked and apply it to, that's considered basically compensatory time. And compensatory time is not available under the Fair Labor Standards Act for private employers. So, and most of us are private employers. Your public employers are going to be your state agencies, governments, etc. Private employers are not allowed to do compensatory time for your non-exempt employees. You do have some flexibility within the same week. So if an individual comes in and you allow it, they want to work 10 hours a day so that they can work 6 hours tomorrow, you could do that, but it's all within that same work week. It cannot roll over from one week to the next, because overtime provisions say that anything over 40 in a work week is overtime. So we cannot carry anything from one week to the next and be in compliance with the Fair Labor Standards Act for overtime pay. So to answer your question, they can't carry it from one week to the next. We can, however, have some flexibility within that same work week to flex those hours. Again, if it goes over 40, it's paid overtime, but if it's 40 or less, they can flex those hours within that week. Hopefully that answers that question. All right, let's see what else we've got here. Okay. Meal periods is time allowed. The employee chooses not to take the time. Okay, that actually goes, okay, so we've got someone here that clicked away from it. I apologize. Get back on that. Come on. All right, so on meal periods, if the time is allowed, in other words, the employer says that the employee has a 30-minute meal period, the employee chooses not to take the time and then leaves the office or goes, doesn't say office or away from their desk, even though the company is insisting they take it, is the time considered worked and must it be paid? This comes back to the enforcement side of the aspect. So we as employers, we can establish policies that says you will take a 30-minute lunch meal period. If the employee elects not to and they remain at their desk, it essentially becomes worked time if they perform any kind of work, and by virtue of remaining at their desk, of course, it's perceived as they are working. But if they don't take that lunch, do any kind of work, we are still going to have to pay them. So then we have to, of course, manage the expectation, which means performance management. So that's going to be having that discussion with the employee, disciplinary action if we have to go to that extent, but putting them on notice that that's against company policy and that if they continue to violate that policy, they're putting their position at risk. So we want to manage that expectation, but the time is paid. If they do it, the time is paid. So we need to, of course, manage the expectation, make sure they understand it so that they don't continue to do that violation in the future. Let's see. Can we get the definition of salaried employees? How do we look it up? Okay, salaried versus, and it really wouldn't be the definition of salaried. What you'd want to look up is exempt versus non-exempt under the Fair Labor Standards Act. And there are very specific categories of exemption. And I want to spout them off the top of my head, but I'm going to miss some. There's administrative. That one is probably the biggest risky one. A lot of people throw individuals into an administrative exemption, call them salaried exempt, even though they're not. There's highly comped IT individuals. Again, IT individuals can be easily misread. You want to make sure that the individuals are performing the actual exempt responsibilities for an IT exemption. There's sales. Let's see, so we've got admin, executive, professional, IT, and outside sales. There are other little ones too, but these are the major categories. They all have guidelines, and they can be found on the Fair Labor Standards Act by simply looking up exempt versus non-exempt or exemptions, and you'll find a hit on that. It'll give you some tests to run your employees through to make sure that they are truly exempt under the Fair Labor Standards Act. And I'd go into more detail, but that could take a whole presentation in and of itself. It is a huge area of risk, and all employers need to be aware that they are sure that they are actually correctly categorizing their employees as exempt versus non-exempt. Okay, let's see, we've got another one here. All right, if an employee's normal scheduled day is 8 to 5 with an hour lunch, and is flying that day and leaves for the airport from home at 8 a.m. Let's see, the flight leaves at 10 a.m. and arrives at the destination at 7 p.m. How many hours would they work for that day? Is normally from 8 to 7 with an hour lunch, or is it 10 to 7? Typically in this case, if the employee is not performing any work tasks during those hours outside of their normal hours. So if their normal hours are 8 to 5, if they're not performing work tasks outside of those hours, the hours that they're actually traveling, normal working hours, would be hours paid. The lunch is a little bit iffier, but if the individual is actually able to have a lunch, which if they're in a plane, on a train, bus, they would be able to break away, have their lunch. I think as long as you set those clear expectations and define that lunch hour exists, even in travel, they're still getting their 8 hours pay during that travel time. The key is making sure that if their travel time goes across the normal working hours, that they are getting paid at least those normal hours, not less than. So the key is to make sure that they're being paid at least those normal hours and nothing less. So we don't want to take away from their pay for something that could potentially have been work time. I hope I answered that one. That one was a little bit more convoluted, so I apologize. I don't see any other questions on here. Looks like we've got just a few more minutes. If anybody's got another question, they would, let's see. We've got another one that just popped in. Let's see what we've got here. Okay, what if the flight is 4 hours? Let's see. Okay, what if the flight is 4 hours long? They still get the 8 hours. Again, it would depend on whether or not you clearly defined those work expectations. So the individual takes off, goes to the airport, they get in the air, they're in the air for 4 hours, that crosses a across their normal working hours, then they arrive at their destination, and they don't have to be anywhere until the next morning at 8 a.m. for a presentation, a conference, a webinar, a seminar, whatever. The rest of that day is theirs to do with as they please, as long as they are not performing hours of work for the employer, so they're not doing work for you on your behalf, for your benefit, then those hours would not be hours worked. So if they're able to use that time effectively for their own purposes, go sightseeing, something like that. But you want to make sure that we define that for them, we set that expectation. So when they take off on this trip, we're going to say your flight leaves at this time and this time. When you arrive, you're free to do whatever you would like. You need to be at the presentation tomorrow morning at 8 a.m. We've now clearly defined for them that that time is theirs to use as they please. Those hours would not have to be paid. So I'll wait to see if any other questions come in. We're getting pretty close to wrapping it up. Looks like we're down to about 2 minutes. Again, the presentation has been recorded. We'll have it available at some future point if someone needs to hear it again. We will have a PDF of the PowerPoint presentation available. And I want to thank everyone for attending and taking the time to join us for this webinar. Again, I hope you found it helpful, and I wish you all a lovely day.